Subcommittee as well as the President-elect IMA KSB 2526. Now, respected President Sir, Dr. Chinwal Sir, the President, the Honorary Secretary of the State, Dr. Suryaraj Sir, the member of the Medical Legal Subcommittee, Dr. Praveen Ramchandra Sir, and the past President, Dr. Srinivas Sir, and all the past President of Indian Medical Association, Karnataka State Branch, the office bearers of Karnataka State Branch, and all the members of different subcommittees, as well as the invitees and the members of Indian Medical Association, Karnataka State Branch, as well as from outside. At this juncture, it is my proud privilege to welcome our Honorable Supreme Court Justice, Sri Justice Gopal Gowda Sir, to this program. I welcome you, sir.
Thank you.
To begin with the program, it is our privilege to render IMA prayer. May I request the Honorary State Secretary, Dr. Suryaraj Sir, to render the IMA prayer, as well as the flag salutation.
Thank you, sir. Welcome all. Welcome Justice ವಿ ಗೋಪಾಲ್ ಗೌಡ ಸರ್. ಮೊದಲನೇದಾಗಿ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಪ್ರಾರ್ಥನೆ, ಎಲ್ಲರೂ ಸಂತೋಷವಾಗಿರಲಿ, ಎಲ್ಲರೂ ಆರೋಗ್ಯವಾಗಿರಲಿ, ಎಲ್ಲರೂ ನೋವಿನಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲರೂ ದುಃಖದಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲ ಆಸೆ ಆಮಿಷಗಳನ್ನು ಮೀರಿ ಗುಣಪಡಿಸುವವರು ನಾವಾಗಿರಲಿ. ಧ್ವಜವಂದನೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜಕ್ಕೆ ವಂದನೆ ಸಲ್ಲಿಸಲು ಇಲ್ಲಿ ನಿಂತಿದ್ದೇವೆ. ಅದರ ಗೌರವ ಮತ್ತು ವೈಭವವೇ ನಮ್ಮ ಬೆಳಕು ಮತ್ತು ಶಕ್ತಿ, ಮತ್ತು ಅದರ ಪಥವೇ ನಮ್ಮ ಪಥವು. ಈ ರಾಷ್ಟ್ರೀಯ ಸಂಸ್ಥೆಯ ಮಾನ್ಯತೆ ಪಡೆದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಅರಿಯುವ ಮೂಲಕ ಅದಕ್ಕೆ ನಮ್ಮ ನಿಷ್ಠೆಯನ್ನು ತೋರಿಸುವ ಪ್ರತಿಜ್ಞೆ ಮಾಡುತ್ತಿದ್ದೇವೆ. ದೇಶ ಸಮೂಹಗಳ ನಡುವೆ ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜವು ಉನ್ನತ ಮಟ್ಟದಲ್ಲಿ ಹಾರಾಡುವ ಸಲುವಾಗಿ ನಮ್ಮ ಅಧಿಕಾರದಲ್ಲಿರುವ ಎಲ್ಲವನ್ನೂ ಅದಕ್ಕೆ ಸಮರ್ಪಿಸುವ ಪ್ರಮಾಣ ಮಾಡುತ್ತಿದ್ದೇವೆ. ಜೈ ಹಿಂದ್. IMA ಚಿರಾಯವಾಗಿರಲಿ. ವಂದನೆಗಳು.
Thank you, sir. Thank you for your kind gesture. I also welcome Dr. Kantikar sir, the member of the National Consumer Forum, the past member of the Consumer Forum. Now it is our privilege to welcome our beloved President, Dr. Chirwala sir, to render his presidential remarks.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ನಮ್ಮ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಎಲ್ಲ ಸದಸ್ಯರಿಗೆ, ಅಲ್ಲದೆ ಇಂದಿನ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಉಪನ್ಯಾಸಕರಾಗಿ ಆಗಮಿಸಿದ ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರಾದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ್ಯಾಯಾಧೀಶರಾದ ಶ್ರೀ ಗೋಪಾಲ ಗೌಡರಿಗೆ ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರವನ್ನು ತಿಳಿಸುತ್ತಾ, ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಶಾಖೆಯ ಅಡಿಯಲ್ಲಿ ಮೆಡಿಕೋ ಲೀಗಲ್ ಉಪಸಮಿತಿಯ ಮೂಲಕ ಇಂದು ಆಯೋಜಿಸಲ್ಪಟ್ಟ ಟಾಪಿಕ್ ರೈಟ್ ಟು ಲೈಫ್, ಎ ಮೆಡಿಕಲ್ ಅಂಡ್ ಲೀಗಲ್ ಪರ್ಸ್ಪೆಕ್ಟಿವ್ ಅಂಡ್ ಇನ್ಸ್ಟೆನ್ಸಸ್ ವೆನ್ ಡಾಕ್ಟರ್ಸ್ ಗೆಟ್ ಪನಿಷ್ಡ್ ಅಂಡ್ ಹೌ ದೇ ಕ್ಯಾನ್ ಬಿ ಅವಾಯ್ಡೆಡ್ ಎನ್ನುವ ಉತ್ತಮವಾದ ಉಪನ್ಯಾಸವನ್ನು ಆಯೋಜಿಸಿದ ಡಾಕ್ಟರ್ ಹರೀಶ್ ದೇಲಂತ ಭಟ್ಟರವರಿಗೆ ಅಭಿನಂದನೆಗಳು. ಈ ಉಪನ್ಯಾಸಕ್ಕೆ ಉಪನ್ಯಾಸಕರಾಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟಿನ ಖ್ಯಾತ ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರಾದಂಥ ಶ್ರೀ ಗೋಪಾಲ ಗೌಡರನ್ನು ಆರಿಸಿರುವುದು ಅತಿ ಹೆಚ್ಚು ಸೂಕ್ತವೆನಿಸುತ್ತದೆ. ಶ್ರೀ ಗೋಪಾಲ ಗೌಡರು ತಮ್ಮ ಹಿರಿಮೆ ಮತ್ತು ಅನುಭವದ ಜೊತೆಗೆ ವೈದ್ಯರಿಗೆ ನೀಡಲ್ಪಡುವ ಶಿಕ್ಷೆಗಳ ಬಗ್ಗೆ ಬೆಳಕು ಚೆಲ್ಲಲಿ ಎಂದು ನಮ್ಮ ರಾಜ್ಯದ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಸದಸ್ಯರ ಪರವಾಗಿ ವಿನಂತಿಸುತ್ತೇನೆ. ಧನ್ಯವಾದಗಳು.
Thank you, sir. Now it is the time to introduce the guest speaker. And before going to that, it was an enlightening judgment by sir somewhere in the year 2013 with regard to civil appeal number 2867 of 2012, Dr. Balram Prasad versus Dr. Kunal Shah and others. So there was a heated discussion among the IMA faculties across the country, and I think sir is going to throw light on this particular judgment too. And now may I request our beloved friend Dr. Ramachandra sir to introduce our beloved guest.
Thank you, sir. Good evening, everybody. Good evening, IMA KSP leadership and our esteemed IMA members. This session I will be moderating. Before we proceed, here are few housekeeping instructions to ensure smooth and engaging session. Please keep your microphones and cameras off. And question and comments, please put it in the chat box, which will take later when the deliberation is over. It is my pleasure to welcome you all for today's seminar of Right to Life and instances where the doctors get punished and how it can be avoided. Right to life is a cornerstone of our constitution protected under Article 21 and is a fundamental to the very essence of human dignity and justice. This topic bridges two critical fields, that is medicine and law, highlighting the responsibilities of healthcare professionals and safeguarding the life while ensuring the ethical and legal compliance. In these sessions, we will explore right to life, both aspects, legal and ethical, and legal accountability and punitive actions, why it occurs against doctors and how to prevent. Now it is my great honor to introduce our esteemed speaker of today's session, Honorable Justice V. Gopala Gowda, who is unparalleled expertise makes him ideal person to address this subject, as told by Sir. Justice Gopal Gowda, born in October 6th of 1951 in Peddur, Chikkaballapur district, Karnataka, and he holds BSc degree from Mysore University and LLB from SJR Law College. Starting his legal journey in 1975, he quickly established himself as a versatile advocate handling constitutional, labor, civil, criminal, and service matters. His academic contribution include teaching roles in Vipuram Law College and Bangalore University. Justice Gopala Gowda's judicial career is very inspiring. He elevated as additional judge in Karnataka High Court in 1987, as permanent judge in 1999, and sworn in as Chief Justice of Orissa High Court in 2010, and elevated to Supreme Court in India 2012, where he served with distinction until his retirement in 2016. Throughout his career, Justice Gopala Gowda has been staunch advocate of access to justice, equity, fairness. His work in Karnataka State Legal Service Authority and National Legal Service Authority exemplifies his commitment to ideals to justice for all. It is my privilege to have such eminent personality with us today to guide us through this critical discussion. Hereby, I welcome Honorable Justice Gopala Gowda, sir, to start his talk. Please, sir.
Thank you, Doctor. Respected President, Secretary, Office Bearers of IMA, former Office Bearers of the IMA, previous member of National
Consumer
Forum, Mr. Kanitkar. He has rendered a human service in that forum to the consumers. This is a very interesting topic which you have given me to talk. Periodical webinars like this, very important for the doctors to mitigate and to avoid the facing of criminal persecution. Apart from that, to be more cautious in discharging the professional duties to the patients in the hospitals. It's very, very difficult. The present day ailments which are being confronting to the people across the country. The contributory negligence, the undisclosed ailments, and to make research to find out what are the type of ailments. Government is the biggest contributor for this. The Constitution, right to life, is a fundamental right guaranteed under Part 3 of the Constitution of India. Our Constitution is a political document, is held by 9-judge constitutional bench in Bommai's case. S.R. Bommai versus Union of India. This is a historical epoch-making judgment. In that, they have said it is a political document. Governance under the Constitution, every organ, either the legislature, executive, and judiciary, required to function within the corners of the Constitution of India. 75 years celebration we have already celebrated in the parliament and the legislative assemblies. Speeches have been made by the Prime Minister, Chief Ministers, Council of Ministers, opposition party leaders. Most unfortunate, 75 years of Republic India, the debate, a healthy debate did not gone on in the Parliament and the Legislative Assembly. That is beside the topic today. I'm incidentally mentioning that. The topic is right to life, medical and legal perspective in India. It's very important to debate and understand the role of the doctors who are the saviors of the lives, millions of people's lives across the country, day in and day out. It is a very Herculean task to treat the patient, to conduct surgeries. And I don't believe that it is not Brahmalikita, the age of a man. If sometimes a serious ailment of cardiac arrest, bypass surgery, cancer, and neurosurgeon operating, pulmonary diseases, you transplant kidney, various ailments, all these are part of the human body. I don't know, people may not know it. Actually, I strongly believe, and my wife always will be telling and debating and discussing that it is the doctors who are the saviors of lives in this universe. There are most efficient doctors in India in all fields. These are the days of super specialties. The medical help or the treatment that are being administered by the doctors and the supporting staff, the nurses, most important in the hospitals. The Constitution contemplates it is the life means a healthy life. A healthy life is what is interpretative of Article 21 judgments of the Supreme Court. In Maneka Gandhi's case, this is a famous 7-judge bench in 1978, 7 judges in the Constitution bench. They have expanded the scope of Article 21, emphasizing procedural fairness, substantive due process. This may be applicable to the purely executives. This is a case of impounding passport of Maneka Gandhi. After declaration of emergency, the Janata Party came into power. At that point of time, Passport Act does not contemplate what is the procedure required to be followed to impound the passport. In that connection, 12th century Dr. Bentley's case was placed reliance. That is alter patrum. Even in the absence of a statutory provision in a statute to follow the procedure, if the action of an authority or the executive entails either civil or criminal consequences, then the principles of natural justice should be read into the statute. That is the principle which is enunciated in Maneka Gandhi's case. That is 7-judge bench of the Supreme Court of India. A right to health as part of right to life is once again recognized. Right, health as an integral to the right to life, mandated the state responsibility to provide medical facilities. State is defined under Article 12. State includes central government, state government, authority. Authority means statute authority, statutory boards. So it is the primary duty cast under the Constitution, and it must be read with Article 21, that provide the health is an integral right to the life. That the duty, constitutional duty cast upon the state. It may be central government, state government, but having regard to the policy of the state government, the health is not an exclusive function of the state today. It is a public function. What is public function is defined in a number of judgments. If an institution or a person is expected to discharge his functions or duties to the public, that is in the nature of the public function. Now, the policy today, the corporate hospitals have come up like mushrooms across the country. That is because of the new economic policies which have been adopted by India, contrary to the preamble of the Constitution of India. That I don't want to go into that area. I'm only speaking that today the Supreme Court has said in Paramananda Katara versus Union of India, reported in 1989, it has been held by Supreme Court. It is the judgment of Supreme Court. It's judgment law. The Constitution, every article, more particularly the Part 3, fundamental rights, is a natural rights to the citizens of the country. Non-citizens also, Article 14 and 19 are attracted. That is dealt in Maneka Gandhi's case and so many other judgments which I don't want to refer to. So this Paramananda Katara versus Union of India, 1989 Supreme Court held, a medical professional is bound to provide aid to a patient in an emergency without legal impediments. This is the duty cast upon a doctor to provide medical aid without any legal impediment. There is no legal impediment. You cannot refuse a patient that I will not treat. It is the cardinal principle. It is the fundamental duty. It is the constitutional duty where Article 21 has been interpreted that you are bound to provide aid to a patient. In India, a passive euthanasia and dignity in death. This right to die with dignity, considered part of the right to life. This Supreme Court has said passive euthanasia has been legalized with strict guidelines. Earlier, it was not permissible. Now, it has been passive euthanasia with reference to dignity in death. For that, the guidelines have been laid down by the Supreme Court of India in a number of cases. The judgment is Common Cause versus Union of India, reported in 2018, upheld the legality of passive euthanasia and recognized living wills. Right to emergency medical treatment. The state has an obligation to ensure that no one is denied emergency medical care due to financial constraints. If this is implemented by letter and spirit, the corporate hospitals cannot take the shelter that I am not a government doctor. My hospital is not a government hospital. I am a corporate hospital. I am not answerable. I am not supposed to treat a patient without paying my charges, the astronomical figures, lakhs of rupees they charge. You know it better than me. This is public talk and debate everywhere today. Sometimes after the treatment, patient dies, the body will not be returned to the caretakers, the wife or the husband or parents, whatsoever may be the case, unless they settle the fee. And there are a number of cases after my retirement came to my notice. I have spoken to them and I told them, even as a judge in Chief Justice in Orissa State, this was brought to my notice. Without filing a petition, I summoned the government advocate and told them, instruct them to deliver the body. Otherwise, the consequences will be serious. So therefore, the judgment in common cause is the right to emergency of medical treatment. The state has an obligation to ensure no one is denied emergency treatment, medical care due to financial restraints. This is not being followed in India, particularly in the corporate sector. It's not doctors responsible. It is the management of the corporate that your association has to take up very seriously in the larger interest of saving the humanity. This has been further held in Pasim Banga Care Mazdoor Samiti versus State of West Bengal, 1996, emphasized that the state's duty to provide timely medical care, the defense that these people will take, that the corporate sector hospitals. I am not a state. I am not supposed to give free treatment to the poor people. I have to charge them. That defense is no more available in view of the 7-judge bench Supreme Court, 2002. What was required to be discharged, performed by the state, central government or state government or authority or a board required to run the hospitals. Those functions by a policy, by way of a policy that they have permitted, granted licenses to run the private corporate hospitals. Therefore, what was being discharged public function by the state government hospitals, that has been substantial in number, transferred by way of a policy to establish a corporate hospital. Therefore, those doctors who are working in the corporate hospital also performing the public functions. This is the law. Now, reproductive rights and maternal health. Reproductive rights, including access to safe abortion and maternal care are part of the right to life. We must have seen the recent government hospitals in Bellary, even some cases in Gulbarga. This is also comes under right to life. The judgment is Suchitra Srivatsava versus Chandigarh administration, 2009. This principle has upheld a right to reproductive autonomy. This is also covered in the judgment of the Supreme Court. Right to refuse medical treatment. A right to refuse treatment, including right to not to be force-fed, has been upheld under Article 21. If a patient, that's what exactly happened. You have seen in that Kisan for the last 6-7 weeks, a farmer leader was sitting hunger strike. Supreme Court directed the state government to take him and give him food. Otherwise, you will be dying. Supreme Court became helpless. You can't force a person to take food. Is what has been recognized by Supreme Court in Aruna Shanbhog versus Union of India, 2011, recognized the right to refuse to life support in certain cases. He can say, I don't want, I will die. So that is also a right to refuse medical treatment is part of Article 21. The right against medical negligence, this most important aspect for the doctors. So doctors are concerned. The secretary was telling the very historical judgment, epoch-making judgment, first time in the Supreme Court, so much of the compensation on the various principles of damages, negligence, performing duties. I have extensively dealt with the case from Calcutta, a doctor, that is the Balram Prasad is a doctor, Balram Prasad is a doctor, versus Kunal Shah and others. So Kunal Shah was the husband of that lady who is a doctor. That I have dealt with, having regard to the finding recorded by the National Consumer Forum, that there was a medical negligence in giving overdosage, the skin eruption, and she became very serious. She was taken to Bombay hospital. She could not be saved. She died. Husband filed a petition claiming damages against the doctors and the corporate hospital of Calcutta. He did not file, not pleaded the hospital, corporate hospital of Bombay. This Kunal Shah himself argued before our bench. He's a doctor. They were all, there is the NRIs in America. So this man himself, like a lawyer, argued 30 volumes of the case law and the voluminous evidence he placed before us. We heard him more than a month. Then the way in which I was a companion judge in the division bench, my senior judge, Justice Chandramouli K.R. Prasad, he requested me to write the judgment since I was very much involved in the case and I was putting number of questions to both the sides. Then my senior brother understood that the damages law and the medical negligence, I am familiar with the law. Therefore, he requested me. It's a voluminous record. It took me more than a month to write the judgment. And he wrote the judgment. I awarded more than 6 crores plus interest. I reduced the damages which were awarded by the National Consumer Forum upon the doctors, because on the principle of the vicarious liability. The employer is liable to pay bear the damages which is caused on account of medical negligence. That is the principle which is involved in Balram case. So, right against medical negligence, protection from medical negligence, a right to compensation are part of the right to life. This is what has been in number of cases the Supreme Court has held with reference to Article 21, keeping in view that you are rendering a service. Your service must be rendered diligently, carefully, without any negligence. Of course, it is a very, very risky job and a very fearful job. And the moment, if it is for any reason, post-care or during conducting a surgery or excess giving a prescription, the treatment that happened in this Balram Prasad case, the victim who died on account of the excess medication prescription, the drugs which were administered was excess. That's the finding of the National Consumer Forum as a fact-finding authority on the basis of material. So therefore, the medical negligence, of course, the Indian Penal Code, the criminal case can also be lodged against the doctors, the community of doctors. When this act, namely the Bharatiya Nyaya Samhita 2023 bill was introduced, the representation was given by the All India Medical Association to the Parliament to delete that provision. Don't bring the doctors if a patient dies during the course of treatment, you shall not make the doctors liable. It's very difficult. That will be abused and misused by the relatives of the patient. This is what is happening across the country, even in our state. These people go and attack the doctors. This has happened, and very difficult for the doctors to function. So therefore, anyway, as long as the Consumer Protection Act is there, you are governed by the Consumer Protection Act. On the basis of the judgments of the Supreme Court, you are required to perform your function. The right against medical negligence, or protection from medical negligence, and the right to compensation are part of, because the victim and the relatives of the victim will be entitled to get the compensation as damages for having lost the precious life of a patient who is a relative of the kith and kin of the person. In this case, Indian Medical Association versus VP Shanta, 1995, brought medical services under the Consumer Protection Act. This judgment holds the field. The definition of consumer services is interpreted by the Supreme Court in this Indian Medical Association. You wanted to wriggle out. The Doctors Association went to the Supreme Court in the year 95 in this VP Shanta's case. So Consumer Protection Act, the medical services is also a service to be provided a patient who is held to be a consumer. A right to clean environment and health. A healthy environment is linked to the right to life and personal well-being. The judgment is Subhash Kumar versus State of Bihar, 1991. In fact, if this judgment would have been applied seriously during the Corona period, the doctors themselves used to tell the patients who are in the ICU or in the wards, the infection of corona virus is very much in the hospitals. After recovering after some period, better to leave the hospital. That is because the healthy environment itself is not maintained in the government hospitals, even in the public sector, the private sector corporate hospitals. That is why if you take action against the concerned, either the Victoria Hospital, Bowring Hospital, or Malleshwaram Hospital, except Jaydeva, or even the environmental, the philosophy, law interpreted by Supreme Court, epoch-making judgments have been written. Even the lawyers who will be arguing in the case in the court hall, there will be environmental protection required. But we are negligent. The state is negligent. All institutions have failed. Not only confined to hospitals. In the hospital, a healthy environment is linked to the right to life. That's why you will not allow a healthy man to enter into the ICU. Some pressure will be there. These people, without knowing, they wanted to see the patient. You strictly adhere. See that virus will be there. You don't come here. The environmental, healthy environment is required to be maintained. Is the judgment of Supreme Court in Subhash Kumar versus State of Bihar. It recognized the right to pollution-free air and water under Article 21. So whatever the air circulating, air condition or no air condition, or the environment of the hospital, and water which is being supplied, it is polluted. That water is being, even the tanks are not cleaned, and toilets are not cleaned, urinals are not cleaned. This is not only the scenario confined to the hospitals, it is the prisons. I have visited number of prisons as a executive chairperson, judge, and the Supreme Court judge. I visited Bangalore, Belagaum, the Parapna Agrahara as a judge. If you go there, no human being, these people must be prosecuted. All these people must be prosecuted. They must be sent to the jail. That is not happening because we are very liberal. The judges are liberal because we don't want to enter into a controversy, confrontation with the state missionary. So this is what is happening. This is another aspect. On this, I can deliver talk more than an hour. Next is mental health and right to life. Very, very, very sad. The new act, somewhere in 2004, is enacted by the parliament. Mental health and right to life. Right to life includes mental health. Is a madman, is if you address, that will affect his dignity. That's why that aspect is taken care of in the Mental Health Act. The insane and all these things are there in the Indian Penal Code and the other enactments. All these things are there. But mental health includes mental health, emphasizing the importance of dignity in treatment. You see, the doctors, before I became a judge, when I was a lawyer, I used to visit mental hospital, neuromedical sciences now, something naming changed now. The way in which these patients behave with the doctor, with the risk of life of a doctor, the doctor will be giving treatment. You see, the Supreme Court has recognized that mental health patients also have a right to life and importance of dignity. They must be treated and given treatment. If you go and see how they behave, the dignity is not at all there. And because the accommodation is not available, many doctors not available, so many things is very horrible. Living mental health patients behave very abnormally. To treat such kind of persons by doctors, that's why you really, God is there, I don't believe. God in your form, doctors, it is you are doing human service. A right to die debate and suicide laws. The Supreme Court has distinguished between suicide and the right to die with dignity, influencing the decriminalization of suicide attempts. The judgment is Gyan Kaur for State of Punjab, 1996, ruled that the right to life does not include a right to die. That's not permissible in India. But allowed passive euthanasia, which I have already told you, with certain guidelines laid down by the Supreme Court in later cases. The court further upheld Section 306 in the repealed Indian Penal Code and 309 IPC, that suicide, that the similar provisions are there in this BNSS, which came into force from July 2024. Right to health and right to life. Governments, the Union of India, state governments, have been held accountable for deficiencies in health infrastructure, population ratio. The hospitals must be provided. We are unable, even after 75 years of independent India celebrations, the primary health center is not provided to a cluster of, at least cluster of gram panchayats. And some gram panchayat, 8 villages, 10 villages. Cluster, 2-3 cluster in the rural India. The hospital infrastructure, where the hospitals are there, doctors are not appointed. Doctors will not go to the rural India. This is the plight. To produce a doctor, we are investing tax-paid money, persons like you and me, 25 lakhs on a doctor, one doctor come out from an institution, medical college. So the right to health and the right to life, governments have been miserably failed and accountable. They are accountable. Deficiencies in health infrastructure for want of immediate, the patient's health, youngsters, these days youngsters, young people are dying on account of heart ailment. The number of the women on account of cancer. Now, number of people, resistance will be there. Immunity level is very high in the rural India people. But for small viral fever, corona, the death rate in rural India is very less. But deaths are taking place on account of non-providing health care, and the government is not providing health infrastructure. This is what Supreme Court has said in the state of Punjab versus Mohinder Singh Chawla, 1997, declared health as a fundamental right. It is a fundamental right. It must be read into Article 21 of the Constitution of India. That is, the right to life is to provide health infrastructure, to give medical care to a citizen of this country is the fundamental right of a citizen. It is a fundamental duty. It is a public function of the state. Medical experimentation and informed consent. Ethical medical practices and informed consent have been affirmed as essential to protect life and dignity. You see, that's why we are very particular and insistent when a patient has to be taken to the OT, operation theatre. You insist and obtain the consent of a patient or the nearest kith and kin. If it is a husband, wife. If you see wife is a patient, husband or son, their signatures are obtained, their consent is required for the purpose of protect life and dignity. I told you that the judgment in Sabira Kohli versus Dr. Prabha Manchanda, 2008, established the need for informed consent before medical procedures. This is what has been said in the Supreme Court. These are all judgments of the Supreme Court, I am telling. Access to medicines and life-saving drugs. Life-saving drugs. The right to life includes access to essential medicines. That is very famous case. Novartis AG versus Union of India, 2013, restricted patent rights to ensure affordable life-saving drugs. That's why that's different names they were selling. High cost is fixed price, and drug control authority consultation, so many tests, life-saving drugs. This Supreme Court has, in this Novartis, is a historical judgment rendered by the bench of the Supreme Court in Novartis age, was Union of India, 2013. Still holds the field. That's the principle. A restricted patent right to ensure affordable life-saving drugs. Case confirmed the Indian Patent Office's rejection of Novartis patent application for the anti-cancer drug, namely Gleevec drug. They rejected the patent right in pursuant to the judgment of Supreme Court. Next, most important is HIV, AIDS, and right to non-discrimination. The discrimination against a patient based on health conditions violates Article 21. No doctor, no hospital dare not to refuse to treat him. If you say that you are treating, you are violating the fundamental right guaranteed Article 21. This is the judgment. That is, the right to privacy, non-discrimination is recognized for HIV patients. That is in the case of Mr. X versus Hospital Judd, 1998. This is a Supreme Court judgment. The judgment was overruled by Mr. X versus Hospital Judd in 2003, 1 SEC, which held the court had exceeded its mandate in making observation as to what rights and obligations arose in case HIV persons plus persons and the right to privacy or confidentiality. The court in that case observed that comments made by the present bench, that is this case, in this case, 2003, except to the extent holding the appellant's right was not affected in any manner in revealing HIV status to the relatives of his fiancé were uncalled for. Supreme Court made observation. If you disclose to relatives or fiancé that is suffering from HIV, that is observations made by Supreme Court was held. It is uncalled for. Next is medical termination of pregnancy. This is also recognized in the Indian Penal Code. This chapter 6 deals with the medical negligence, causing death by negligence, 106, and causing miscarriage without woman's consent. This chapter 5, deals with offenses against woman and child. So the Supreme Court, medical termination of pregnancy, MTP, the right to life includes reproductive choices and safe abortion rights. Judgment in X versus Union of India, the latest is 2022, allowed unmarried women access to abortion under the MTP Act. So if you unmarried woman, termination of pregnancy is permitted. To that extent, it may not affect Article 21. It is, on the other hand, it is permissible you can't, that is within the period of 24 weeks. That's what is Supreme Court has said. So the medical termination of pregnancy includes reproductive choices, safe abortion rights. This is what has been held in 2022. On September 29, 2022, Supreme Court of India ruled that all women, irrespective of marital status, have equal access to abortion up to 24 weeks of the gestation period. The case involved a 25-year-old unmarried woman who was around 22 weeks pregnant from a consensual relationship that was permitted to be terminated. This is what is recognized by the Supreme Court. The use of third-degree force on prisoners is violated of Article 21. That may not apply to you. The importance of dignity in health related, the Supreme Court, decision of Supreme Court for transgender people. The Supreme Court in the case, there's National Legal Services Authority, which is controlled by the Supreme Court of India. CMO's judge is the executive chairperson. Null 14. Court held that third gender person should be subjected to any medical examination or biological test which would invade their right to privacy. The court interpreted dignity under Article 21 of the Constitution to include diversity in self-expression, which allowed a person to lead dignified life. The emphasis a very judgment, health-related, health treatment with care and caution. HIV patient, ordinary patient, it is referable to the dignity and privacy is recognized, which is read into Article 21. Article 21 has been interpreted. It is the evolution of the case law. It is interpretation of Article 21 with reference to the functions of the doctors and state government to provide health care to the residents and citizens of the country. So life is guaranteed 21. Dignity life is guaranteed 21. Medical health is read into Article 21. All these things we must create awareness to our doctor friends that is while discharging your professional, efficient, super specialty doctors, you must always keep in mind that these are the judgments which are there. If any negligence anywhere, of course, you may not be damages is concerned. But if it is also a criminal act, negligence in treating a person and die on account of negligence, you will also be personally liable for prosecution. So, and you are also rendering a service attracts Consumer Protection Act 1986. This is the law with regard to the right to life, medical and legal perspective in India. This is what is the contribution made by the Supreme Court interpreting Article 21 of the Constitution of India. I told you that Chapter 5, Chapter 6 of the Indian Penal Code attracts with regard to the miscarriages without consent and detection and abortion on the basis of the fetus carry either a female girl or a male girl. If it is a female girl, pregnancy is terminated, is not permissible. It is an offense under Chapter 5. And medical negligence, treating a patient dies or suffers serious ailments and go into the coma. These are all medical negligences for which the doctor, insofar as the pecuniary liability is concerned, the employer may have to give it as a vicarious liable, even in the state government hospitals or private hospitals. That's what I have said in Balram Prasad case, vicariously liable. Therefore, I reduced to 25 lakhs to the doctors. It was more than that. Keeping in view doctor's salary and all these things, I have modified that portion of the judgment in this Balram and Kunal Shah case. So this is in short, this is the topic deals with the law, liberty, medical health, and medical aid in respect of all types of the patients which we are treating in India. Any questions? I can answer. I have taken more than 45 minutes.
Yeah. Thank you, sir, for your very enriched deliberation. We appreciate your talk. It was excellent and we follow. We as a doctors, we are here to serve the community. We are also the part of the community. For example, my father is also a farmer. We know how difficulty in the situation in the communities. But the situation at times as a professional, we have some other challenges too. For example, as an individual or as a professional, sometimes being in a small place like a taluka place or a village, sometimes it's very difficult to face the challenges, especially violence on doctors. And this is across the country. This is happening in our day-to-day basis, and it is a challenge for IMA also, because to safeguard the members as well. There is one more challenge. Next, because of all these laws, at times the small hospitals and the medium hospitals which are in the peripheral, they are finding it difficult to run the service because of so many laws guarding the profession, as well as the schemes, insurance schemes, which are more beneficial to the corporate hospitals. So the small hospitals and the medium-sized hospitals are in the verge of closing. And we have seen no new establishments are coming up in the village as well as in the taluka level because of so many issues like this. So people are trying to be more safe and more defensive. Even when you see the postgraduate medical students, they try to take up medicine very safer bet than going to surgery and other tough subjects. So I can see within 100 ranks, more than 50 students have taken up medicine. That means to say, in future, we may not have many surgeons or surgical field in the peripheral as well as the taluk levels. Naturally, they have to go to the corporate where these people are being appointed. So the days are very tough ahead. So with all this in mind, again, someone has asked the criminal part of the law. When we'll get arrested for tribal reasons, and so many laws pertaining to the ultrasound and other
Treatment.
services. So all these things are really bothering our medical professions. As far as the death rate is concerned, as you say in general public, it is also very high in our medical professions. Today we could see two people are, one is a neurologist aged about 45, while delivering a neurology seminar in a conference, suddenly collapsed. So such things are happen now and then because our doctors are also stressed. So with all these, I think our humble request to the fraternity, to the judiciary officers, to kindly take care of our grievances also, look into our grievances also at these junctures.
Case by case, it will be examined.
Sir,
Yes.
why do you think this violence against doctor is increasing, sir? In your perspective, why you
That
think?
is proper protection is not there for the doctors in the hospitals. And sometimes the people will not accept the sudden death or not giving treatment to a pregnant woman. She dies. They will become angry. Therefore, this is what Supreme Court has said, that if you can't refuse to give treatment, you have to give the treatment to the patient. That's what exactly what is happening is not lack of education. The cultural values are not there. People suddenly become anger. All these things are cumulative effect of sudden attack on the doctors. Therefore, in the hospitals, that's what why the guidelines have been KG Kar Hospital. That lady was killed. It's proper security is not provided in the big hospitals like Victoria Hospital. Of course, police station is there. That is, but they must ensure that doctors will discharge freely. This is insofar as the government hospital are concerned. The corporate hospitals are concerned, there will not be any police station, no police people will be there. They must have their own security people to protect the doctors inside the hospital. And these two aspects. One is management must provide and take care of the protection aspect of the doctors who will be working. And if they take the law into their hands, police people must deal them firmly. And courts also, these people don't collect evidence and all these things. That's why acquittal. There must be stringent law to be enforced against such the barbaric people, uncivilized acts, committing the offences, assault upon the doctors is not appreciated. They must deal them with iron hand. And the hospitals safe security must be provided. That is not there. That's the reason.
Now I invite Renuka Devi, Dr. Renuka Devi, to ask her question.
Oh, please, first let her ask.
Dr. Renuka, you are around?
I think she's muted. All are muted. I think if you want, they can unmute. May I request John to unmute Dr. Renuka Devi so that she can ask the question.
Sir, shall I?
Yeah, please.
Hello.
Introduce
please.
yourself and ask a question.
It is not a question.
Okay.
Sir, ಜಸ್ಟಿಸ್ ಗೋಪಾಲ್ ಗೌಡ್ರದು ಕಾಣ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ, ಅದು ನನಗೆ ಪವರ್ ಹೋಗಿದೆ. ಇಲ್ಲಿ
ಓಹೋ.
ಪವರ್ ಹೋಗಿದೆ.
ಓಕೆ ಸರ್.
ಇದು ಪವರ್ ಇದರಲ್ಲಿ ಫಂಕ್ಷನ್ ಆಗ್ತಾ ಇದ್ದೀನಿ ನಾನು.
ಎಸ್ ಸರ್, ಇದು ಡಾಕ್ಟರ್ಸ್ ಮೇಲೆ ಲಿಟಿಗೇಷನ್ಸ್, ಹಲ್ಲೆಗಳು, ಅಲಿಗೇಷನ್ಸ್ ಇವು ಎಲ್ಲ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದು ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಸ್ಟಾರ್ಟ್ ಆದ ನಂತರ.
ಹೌದೌದು.
ಇಲ್ಲಿವರೆಗೂ ವೈದ್ಯೋ ನಾರಾಯಣ ಹರಿ ಅಂತೇಳಿ ಏನಂತಲ್ಲ, ನಾನು ಸಿನ್ಸ್ 1980 ಐ ಆಮ್ ಪ್ರಾಕ್ಟಿಸಿಂಗ್ 79 to 9. ಆಗ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದಂಥ ಒಂದು ವಾತಾವರಣ ಈಗಿಲ್ಲ. ಅವಾಗ ಏನಾಗ್ತಿತ್ತು ಏನಂತಲ್ಲ, ನಾವು ಬಂದಂಥ ರೋಗಿಗಳಿಗೆ ಯಾವುದೇ ಇರಲಿ ಮೊದಲು ಪೇಷಂಟ್ಗೆ ಆರಾಮ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಕಳಿಸ್ಬೇಕೆಂಬ ಒಂದು ಇದರಿಂದ ನಾವು ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ವಿ. ಆದರೆ ಈಗ ಬಂದಾಗ ಒಂದು ಎಮರ್ಜೆನ್ಸಿ ಕೇಸ್ ಬಂತಂದ್ರೆ ಒಂದು ವಿ ಆರ್ ಕೆಪಬಲ್ ಟು ಹ್ಯಾಂಡಲ್ ದಿ ಕೇಸ್. ಬಟ್ ಟೆಂಡರ್ಸ್ ಅಂಡ್ ಲಿಟಿಗೆಂಟ್ಸ್ ಇದಾರೇನಪ್ಪ, ಹೇಗಿದ್ದಾರೆ ಅಂತ ತಿಳ್ಕೊಂಡು ಏನಂತಲ್ಲ, ವಿ ವಾಂಟ್ ಟು ಪುಷ್ ಆಫ್ ಏನಂತಲ್ಲ ಡಿಫೆನ್ಸಿವ್ ಇದನ್ನ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾ ಇದೆ ಈಗ. ಸೊ ಇದು
ವೆರಿ ಬ್ಯಾಡ್, ಅದು ಬಹಳ ಕೆಟ್ಟದ್ದು.
ಇದು ಬಹಳ ಕರೆ ಒಂದ್ರಂದ್ರ ಏನಾಗುತ್ತಾ, ಈಗ ಪೇಷಂಟ್ಸ್ ಒಂದು ಹಾಸ್ಪಿಟಲ್ ಇನ್ನೊಂದು ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೀಗೆ ಹಾಕ್ಯಂತ ಹೋದ್ರ ಆನ್ ದಿ ವೇ ದೇ ಮೇ ಕೊಲ್ಯಾಪ್ಸ್.
ಹೌದೌದು.
ಸೊ ಇದು ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ಇಂದ ಡಾಕ್ಟರ್ಸ್ ಹೊರಗೆ ತರಬೇಕಾದ ಏನಂತಲ್ಲ, ತಮ್ಮ ಅಭಿಪ್ರಾಯ ಏನಿದಕ್ಕೆ?
ಇಲ್ಲ, ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ರಿವರ್ಸ್ ಮಾಡ್ಬೇಕದು. ಅದು ಮಾಡ್ತೇನೆ ಪಾರ್ಲಿಮೆಂಟ್. ಆಫ್ ಕೋರ್ಸ್ ದಿ ಪೀಪಲ್ ಮಸ್ಟ್, ನೀವು ಇವಾಗ ದಿ ರೇಟ್ ಆಫ್ ದಿ ಮೆಡಿಕಲ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇನ್ ದಿ ಪ್ರೈವೇಟ್ ಹಾಸ್ಪಿಟಲ್ಸ್, ನೀವು ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ತಗೊಂಡ್ರೆ
Yes, sir.
Inefficient people, I am not only confining to your profession, inefficient even in our judiciary, from here to Supreme Court. I am taking it to confidence, I am telling you. Lawyers, ಎಲ್ಲ ಫೀಲ್ಡ್ ಅಲ್ಲಿ ಇನ್ಎಫಿಷಿಯನ್ಸಿ ಇದೆ. ಇಲ್ಲಿ ಎಲ್ಲ ಈ ಎಕ್ಸಾಮಿನೇಷನ್ಸ್ ಎಲ್ಲ ಹೆಂಗ್ ನಡೀತದೆ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ.
ಹಾ,
ಪ್ರೊಫೆಸರ್ಸ್
ಹೌದು
ಆಮೇಲೆ PhD ಬರೆಯೋರು, ಇದು ಸಮಾಜದಲ್ಲಿ ಹೋಲಿಸ್ಟಿಕ್ ಆಗಿ ನಾವು ಚೇಂಜ್ ಮಾಡಿದೇನೆ ನಾವು ಈ ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಅದು ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇನ್ನೂ ಬಹಳ ಈ ಇನ್ಎಫಿಷಿಯಂಟ್ ಪೀಪಲ್ ಈ ಪ್ರೈವೇಟ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ನೋಡಿ ನೀವು ಎಲ್ಲರೂ ಬಹಳ ವಿತೌಟ್ ಡಿಸ್ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಕಾರ್ಪೊರೇಟ್ ಹಾಸ್ಪಿಟಲ್ಸ್, ಪ್ರೈವೇಟ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಬರ್ತಕ್ಕಂಥ ಎಲ್ಲ ಡೊನೇಷನ್ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಸ್ಟೂಡೆಂಟ್ಸ್ ಬರ್ತಾ ಇದ್ದಾರೆ. ಇಲ್ಲಿ ಇಲ್ಲಿ ನೀವು ಅವ್ರ ಟ್ರೀಟ್ಮೆಂಟ್ಗೂ ಇವಾಗ ಪ್ರವೀಣ್ ರಾಮಚಂದ್ರ ಅವರು ಟ್ರೀಟ್ಮೆಂಟ್ಗೂ ನಿಮ್ಮ ಟ್ರೀಟ್ಮೆಂಟ್ಗೂ ವಿಕ್ಟೋರಿಯಾ ಹಾಸ್ಪಿಟಲಲ್ಲಿ ನಿಮ್ಮಂಥವರೆಲ್ಲ ಡಾಕ್ಟರ್ಸ್ ಎಲ್ಲ ಇದ್ದಾರಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲಲ್ಲಿ ಮತ್ತೆ ಕಾರ್ಪೊರೇಟ್ ಸೆಕ್ಟರ್ನಲ್ಲಿ ನಿಮ್ಮಂಥವ್ರು ಬಹಳ ವಿರಳ ಇದ್ದಾರೆ. ಇವಾಗ ಬಹಳಷ್ಟು ಜನರು ಇವಾಗ ಮೋಸ್ಟ್ ಇನ್ಎಫಿಷಿಯೆಂಟ್ನವರು ಇಲ್ಲಿ ಬರ್ತಾ ಇದ್ದಾರೆ. ಆದ್ರಿಂದ ಅದನ್ನ ತೆಗೆದಾಕ್ಬಿಟ್ರೆ ಇನ್ನೂ ಸ್ವಲ್ಪ ತೊಂದರೆ ಆಗ್ತಕ್ಕಂಥ ಸನ್ನಿವೇಶ ಇರ್ತದೆ ಅಂತ ನನ್ನ ಒಂದು ಅಭಿಪ್ರಾಯ. ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಅದಿಲ್ಲ ಅಂದ್ರೆ ಬಹಳ ಜನರು
ಇತ್ತೀಚೆಗೆ ಈ ಪ್ರೆಸಿಡೆಂಟ್ ಗವರ್ಮೆಂಟು ಅಲೋಪೆಥಿಕ್ಕು, ಆಯುರ್ವೇದಿಕ್ಕು, ಹೋಮಿಯೋಪೆಥಿಕ್ ಎಲ್ಲವೂ ಮೂರನ್ನು ಕೂಡಿಸಿ ಒಂದು ಇಂಟರ್ಮೀಡಿಯೇಟ್ ಹೆಲ್ತ್ ಕೇರ್ ಸಿಸ್ಟಮ್ ಮಾಡಬೇಕು ಎಂಬ ಒಂದು ಪ್ರಯತ್ನ ನಡೆದಿದೆ. ಬೈ 2030 ಒಳಗಾಗಿ ನೀವು ಅಲೋಪೆಥಿ, ಆಯುರ್ವೇದ, ಹೋಮಿಯೋಪೆಥಿ ಮೂರನ್ನು ಕೂಡಿಸಿ ಏನಂತಾರೆ ಒಂದು ಪೇಷಂಟ್ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಬಂತಂದ್ರೆ ಹಾಸ್ಪಿಟ್ಲಲ್ಲಿ 3 ತರಹದ ಇರಬೇಕು, ಅವ್ರಿಗೆ ಯಾವ ಟೈಪ್ ಬೇಕು ಆ ರೀತಿ ಮಾಡಬೇಕು ಅಂತಂಬುದೊಂದು ಇವತ್ತಿನ ಪೇಪರ್ನಲ್ಲಿ ನಾನು ಓದಿದೆ.
ಅದು ಇದೆ ಅದು ಬೇಕಾಷ್ಟು ಇದೆ, ಅದನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಲ್ಲ ಇವರು.
ಅದೇ
ಇಂಪ್ಲಿಮೆಂಟ್ ಇವಾಗ ಮೆಡಿಕಲ್ ಕಾಲೇಜಸ್ ಡೊನೇಷನ್ ಅಲ್ಲಿ ಎಲ್ಲ ಪಾಲಿಟಿಷಿಯನ್ಸ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಹೌದು,
ಅವರಿಗೆ ಯಾವ್ಯಾವ ರೀತಿ ಅಡ್ಮಿಷನ್ ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಎಲ್ಲ ಎಕ್ಸಾಮ್ಸ್ ನಲ್ಲಿ ಎಲ್ಲ ಇಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಕೆಲಸ ಕಾಲೇಜಿಗೆ ಬರದೇನೆ ಪಾಸ್ ಮಾಡಿಸ್ತಕ್ಕಂಥದ್ದು ಇವೆಲ್ಲ ನಡೀತಾ ಇದೆ ಇವಾಗ UPC ಪ್ರೊಫೆಷನಲ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಕ್ಕಂಥ ಡಾಕ್ಟರ್ಸ್ಗೆ ಈ ಸಮಸ್ಯೆ ಇರಲ್ಲ. ಯಾರು ಪ್ರೊಫೆಷನಲ್ ಇಲ್ದೇನೆ ಬೇಕಾಬಿಟ್ಟಿ ಮಾಡ್ತಕ್ಕಂಥವ್ರಿಗೆ ಈ ಸಮಸ್ಯೆ ಬರುವುದು. ಇದ್ರ ಜೊತೆಗೆ ಪಾಪ ಒಳ್ಳೆ ಡಾಕ್ಟರ್ಸ್ ಸಿಕ್ಕಾಕೊಂಡ್ಬಿಡ್ತಾರೆ, ಸಿಗ್ತಾ ಇದ್ದಾರೆ. ಇದು ಬಹಳ ದುರಂತ. ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಗ್ತದಿಂದ ಮೆಡಿಕಲ್ ಪ್ರೊಫೆಷನಲ್ಸ್ ಇವಾಗ ನನ್ನ ಪ್ರಕಾರ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದ ಮೇಲೆ ಲಾಯರ್ಸ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಂದ ಎಷ್ಟೋ ಜನರು ಕೇಸ್ಗಳು ಕಳ್ಕೊಂಡ್ಬಿಡ್ತಿದ್ದಾರೆ.
ಹೌದು ಸರ್.
ಎಷ್ಟೋ ಜನರು ಒಳಗಡೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ, ಡೆತ್ ಸೆಂಟೆನ್ಸ್ ಅವೆಲ್ಲ. ಇದು ಇನ್ಎಫಿಷಿಯನ್ಸಿ ನಾಟ್ ಕನ್ಫೈನ್ ಟು ಒನ್ ಫೀಲ್ಡ್, ಒನ್ ಸೆಕ್ಟರ್ ನಲ್ಲಿ ಅಲ್ಲ, ಎಲ್ಲ ಸೆಕ್ಟರ್ ನಲ್ಲಿ ಇನ್ಎಫಿಷಿಯನ್ಸಿ ಜಾಸ್ತಿ ಆಗ್ಬಿಟ್ಟಿದೆ
ಸರ್. ಈಗ ಒಂದು ಕೋರ್ಟ್ನಲ್ಲಿ, ತಾಲೂಕಾ ಕೋರ್ಟ್ನಲ್ಲಿ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಆಗುತ್ತೆ, ಅದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟಿಗೆ ಅಥವಾ ಹೈಕೋರ್ಟಿಗೆ ಹೋದಾಗ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕಂಪ್ಲೀಟ್ಲಿ ಚೇಂಜ್ ಆಗುತ್ತೆ.
ಹೌದು,
ಎಲ್ಲವೂ ಏನಂತಲ್ಲ ಬೇಸಿಕ್ ಅಂತಲ್ಲಪ್ಪ ಅಲ್ಲಿ ಪ್ಲೀಡರ್ ಮಾಡಿದ್ದೆಲ್ಲವೂ ಸೇಮ್ ಸಬ್ಜೆಕ್ಟ್ ಇರ್ತದೆ, ಬಟ್ ದಿಸ್ ಒನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಸ್ ಟೋಟಲಿ ಡಿಫರ್ ಆಗುತ್ತೆ
ಅಲ್ಲಿ. ಅದೇ ಇದೇನಾಗಿದೆ, ಅದಕ್ಕೋಸ್ಕರ ಹೈರಾರ್ಕಿ ಆಫ್ ಕೋರ್ಟ್ಸ್ ಇರುವುದು. ಒಂದೇನಪ್ಪ ಅಂತ ಹೇಳಿದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನ ರಿವರ್ಸ್ ಮಾಡಿದ್ರೆ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ರೈಟ್ ಅಂತ ನಾವು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಇದೆ. ಇಲ್ಲಿ ಮೂಲಭೂತವಾಗಿ ಕಟ್ಟಲೆ ಆಗ್ಲಿ ಅಥವಾ ಟ್ರೀಟ್ಮೆಂಟ್ ಆಗ್ಲಿ ಅದನ್ನ ಪರಿಪೂರ್ಣವಾಗಿ ಸರಿಯಾಗಿ ಅರ್ಥೈಸ್ಕೊಂಡು ಅದಕ್ಕೆ ಸರಿಯಾಗಿ ಒಂದು ಡಿಸಿಷನ್ ಬಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಕಿಂಗ್ ಪ್ರೊಸೆಸ್ ಇದೆಯಲ್ಲ, ಇದು ಯಾವುದಿದು ಕಾಯಿಲೆ ಏನ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಟ್ಟರೆ ಸರೋಗ್ತದೆ ಅಂತಕ್ಕಂಥದ್ದನ್ನ ಡಿಸಿಷನ್ ತಗೊಳ್ಳೋದಿದೆಯಲ್ಲ, ಅದೇನೆ ಬಹಳ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್.
ಸರ್, ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಮೊನ್ನೆ ಚೆನ್ನೈದಲ್ಲಿ ಒಬ್ಬ ಡಾಕ್ಟರ್ ಬಾಲಾಜಿ ಮೇಲೆ ಹಲ್ಲೆ ಮಾಡಿದ್ರು.
ಹೌದು,
ಆಕ್ಚುಲಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಏನಂತಾರೆ ಕ್ಯಾನ್ಸರ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಗಿವ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆದರೆ ಬೇರೆ ಒಬ್ಬ ಯಾರೋ ವೈದ್ಯರು ನಿಮ್ಮ ತಾಯಿ ಕೊಟ್ಟಂತ ಟ್ರೀಟ್ಮೆಂಟ್ ಸರಿಗಿಲ್ಲ ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಅವನು
ಅದೇ ಇದು ಅನ್ಪ್ರೊಫೆಷನಲ್ ಆಗಿ ಕಂಡಕ್ಟ್ ಮಾಡ್ಕೊಳ್ತಿದೀವಿ ನಾವು. ಅದನ್ನ ಅವ್ರ ಹತ್ರ ಹೋದಾಗ ಅವೆಲ್ಲ ಹೇಳಕ್ ಹೋಗ್ಬಾರ್ದು. ಸರಿ ಇದೆಯಾ ಸರಿ ಇಲ್ವಾ ಅಂತಕ್ಕಂಥದ್ದನ್ನ ಇನ್ನೊಂದು ಪ್ರೊಫೆಷನಲ್ ಮೇಲೆ ಹೇಳ್ತಕ್ಕಂಥದ್ದು ಸರಿ ಇಲ್ಲ. ಅದು ಬೇರೆ ಬೇರೆ ರೀಸನ್ಸ್ ಇರ್ತದೆ. ಇವಾಗ ನೀವು ಟ್ರೀಟ್ಮೆಂಟ್ ಸರಿಯಾಗಿ ಕೊಟ್ಟಿರ್ತೀರಿ, ಇವು ಸರಿಯಾಗಿ ಫಾಲೋ ಮಾಡಲಿಲ್ಲ, ಪೋಸ್ಟ್ ಆಪರೇಷನ್ ಸರಿಯಾಗಿ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಅದನ್ನು ನೋಡ್ಬೇಕು, ಅದು ಆಸ್ಪೆಕ್ಟ್ನ. ಇವಾಗ ಪೋಸ್ಟ್ ಆಪರೇಷನ್ ಕೇರ್ ಇದೆಯಾ ಇಲ್ವಾ? ಪೋಸ್ಟ್ ಆಪರೇಷನ್ ಕೇರಲ್ಲಿ ಪೇಷಂಟು ಅಥವಾ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಆದ್ರೆ ನೀವು ಹಿಂಗೆ ನೆಗ್ಲಿಜೆನ್ಸ್ ಬರ್ತದೆ. ನೆಗ್ಲಿಜೆನ್ಸ್ ಸಕ್ಸಸ್ಫುಲ್ ಆದ್ರೆ ಆಮೇಲೆ ಪೋಸ್ಟ್ ಆಪರೇಷನ್ ಕೇರ್ ತಗೊಂಡಿದ್ರೆ ಫಾರ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಏನೋ ಆಗಿ ಸತ್ತೋಗ್ಬಿಟ್ರೆ ನೀವ್ ಹೆಂಗ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಅದಕ್ಕೆ? ಅದಕ್ಕೆ ಅದ ಬಹಳ ಕೇರ್ಫುಲ್ ಆಗಿ ಆ ಎವಿಡೆನ್ಸ್ ನ ತೆಗೆದುಕೊಂಡು ರೆಕಾರ್ಡ್ ಮೇಲೆ ಹಾಕ್ಬೇಕು. ಅದನ್ನ ಅಪ್ರಿಸಿಯೇಟ್ ಮಾಡುವಾಗ ಕರೆಕ್ಟ್ ಆಗಿ ಲಾಯರ್ ಅದನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ಬೇಕು.
ಸರ್, ಪಾರ್ಲಿಮೆಂಟ್ ನಲ್ಲಿ 2019 ನಲ್ಲಿ ರಾಮವಿಲಾಸ್ ಪಾಸ್ವಾನ್ ನಮ್ಮ ಮಿನಿಸ್ಟರ್ ಇದ್ರು ನೋಡಿ, ಕನ್ಸ್ಯೂಮರ್ ಇದ್ರ ಸಲುವಾಗಿ ಆಕ್ಚುಲಿ ವಾಂಟೆಡ್ ಟು ರಿಮೂವ್ ಹೆಲ್ತ್ ಕೇರ್ ಫ್ರಮ್ ದಿ ಕನ್ಸ್ಯೂಮರ್, ಬಟ್ ಐ ಡೋಂಟ್ ನೋ ವಾಟ್ ಹ್ಯಾಪನ್.
ಅಲ್ಲಿ ಇದೊಂದು ಆಸ್ಪೆಕ್ಟ್ ನಾವು ನೋಡ್ಬೇಕಾಗಿದೆ. ಇದು ಫ್ಯಾಕ್ಚುಯಲ್ ಆಸ್ಪೆಕ್ಟ್, ಇಟ್ಸ್ ಅ ಫ್ಯಾಕ್ಟ್. ಇದು ಮೋರ್ ದನ್ 50% ಕಾರ್ಪೊರೇಟ್ ಹಾಸ್ಪಿಟಲ್ಸ್ ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥವ್ರು, ವಿತ್ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್, ನಿಮಗೂ ಗೊತ್ತಿರ್ತದೆ, ನಿಮಗೂ ಮಾಹಿತಿ ಇರ್ತದೆ. ಅಲ್ಲಿ ಈ ಡೊನೇಷನ್ ಸೀಟ್ಸ್ ಬರ್ತಾರಲ್ಲ, ಅವರೆಲ್ಲರೂ ಬಹಳ ಬೇಕಾಬಿಟ್ಟಿ. ಅದು ತೆಗೆದಾಕ್ಬಿಟ್ರೆ ಸ್ವಲ್ಪ ಡೇಂಜರ್ ಇದೆಯೇನೋ ಅಂತ ನನ್ನ ಒಂದು ಅಭಿಪ್ರಾಯ. ಅದಕ್ಕೆ ಇವಾಗ ಒಳ್ಳೆ ಡಾಕ್ಟರ್ಸ್ಗೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಈ ಸಬ್ಜೆಕ್ಟೇ ಗೊತ್ತಿಲ್ಲದೆ ನೆಗ್ಲಿಜೆಂಟ್ ಆಗಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡ್ತಕ್ಕಂಥವ್ರಿಗೆ ತೊಂದರೆ ಆಗ್ತದೆ. ಇದರಲ್ಲಿ ಸಮಟೈಮ್ಸ್ ಅವ್ರು ತಪ್ಪಿದ್ರು ಕೂಡ ಅವ್ರು ಸತ್ತೋದ್ರೆ ಇವ್ರ ಮೇಲೆ ಅಟ್ಯಾಕ್ ಮಾಡೋದು ಸರಿ ಇಲ್ಲ, ಅದು ಸರಿ ಇಲ್ಲ.
ಅದಕ್ಕೆ ಏನಂತಲ್ಲ ಸರ್, ಈಗ ಲಾಯರ್ಸ್ಗಾಗ್ಲಿ ಆಮೇಲೆ ಆಡಿಟರ್ಸ್ಗಾಗ್ಲಿ ಏನಂತಲ್ಲ, ಈ ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ನಿಂದ ಹೊರಗಡೆ ಇದೆ. ಅದೇ ರೀತಿ
ಲಾಯರ್ಸ್ ಇಲ್ಲ ಅದರಲ್ಲಿ, ಕನ್ಸ್ಯೂಮರ್ ನಲ್ಲಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಲಾಯರ್ಸ್ ಅನ್ನು ಯು ಮಸ್ಟ್ ಬ್ರಿಂಗ್ ದೆಮ್ ಅಂಡರ್ ದಿ ಕನ್ಸ್ಯೂಮರ್ ಫೋರಂ, ಕನ್ಸ್ಯೂಮರ್ ಆಕ್ಟ್ ನಲ್ಲಿ ತರಬೇಕು ನನ್ನ ಪ್ರಕಾರ.
ಅದಕ್ಕೆ ಈಗ ಡಾಕ್ಟರ್ಸ್ ಅದನ್ನ ಸ್ವಲ್ಪ ಏನಂತಲ್ಲ, ಆಕ್ಚುಲಿ ಯಾರು ಪ್ರಾಮಾಣಿಕವಾಗಿ ಮಾಡುವಂತ ವೈದ್ಯರಿಗೆ ಇದು ಬಹಳ ತೊಂದರೆ ಆಗ್ತದೆ ಸರ್.
ಅದಾಗ್ತದೆ, ಆಗ್ತಾ ಇದೆ, ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ, ನೋಡ್ತಾ ಇದ್ದೀವಿ.
ಈಗ ಲಾಯರ್, ಅಡ್ವೊಕೇಟ್ಸ್ ಅಥವಾ ಬೇರೆ ಪ್ರೊಫೆಷನಲ್ಸ್ ಕನ್ಸ್ಯೂಮರ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಆ ಒಂದು ಲಾ ಅಲ್ಲಿ ಒಂದು ಏನಿದೆ ಅದನ್ನ ತಗೊಂಡು ಈ ಎಲ್ಲ
that will be a good point to urge to reconsider the law. It's a good point.
Similar profession, similar thing. Why are you
differentiating and discriminating between one same? The law professionals also professionals, doctors also professionals. Why are you discriminating and you bring these people one section doctors? You are excluding the auditors and ivargella anta.
Usually by writ petition like that, na sir? Usually.
And samata mechanism we have to, other than this ಮಾಡಬೇಕು. ಬಟ್ IPC ನಲ್ಲಿ ಕೂಡ ಇವೆಲ್ಲ ಇವೆ. ಅಂಥವ್ರಿಗೆ ಇಂಡಿಯನ್ ಪಿನಲ್ ಕೋಡ್ ನಲ್ಲಿ ಆ ಸೆಕ್ಷನ್ಸ್ ಇರಲೇಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ ಜನರನ್ನ ಅವರ ಅಕೌಂಟಬಲ್ ಇಲ್ದೇನೆ ಬಿಹೇವ್ ಮಾಡ್ತಾರೆ. ಅಕೌಂಟಬಿಲಿಟಿ ಇರಲೇಬೇಕು ಪ್ರತಿಯೊಬ್ಬರಿಗೂ ಕೂಡ. Accountability even for the Supreme Court judge. That's why I will be telling in all my public speeches, a wrong judgment must be criticized. We must tell them it's a wrong judgment, it's ಇದರದ ಪರಿಣಾಮ ಏನಾಗ್ತದೆ ಅಂತ ನೋಡಿ. ಇವಾಗ ಡ್ರಾಫ್ಟ್ UGC 70 ಇದೆಯಲ್ಲ, ಇದು ವೈಸ್ ಚಾನ್ಸಲರ್ಸ್ಗೆ, ಅದಕ್ಕೆ ನಿನ್ನೆ ಹಿಂದೂ ಪೇಪರ್ನಲ್ಲಿ PDT ಆಚಾರ್ಯರು ಬರೆದಿದ್ದಾರೆ. ನಾನು ಇವತ್ತು ಸಾಯಂಕಾಲ ಓದ್ದದು. ಸೊ ಆ ರೀತಿ ಕ್ರಿಟಿಸಿಸಮ್ ಅನ್ನ ಅನ್ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್, ಇಟ್ ಇಸ್ ಇಲ್ಲಿಗಲ್, ಕಾಂಟ್ರಾರಿ ಟು ಜಡ್ಜ್ಮೆಂಟ್ಸು, ಇದು ತೊಂದರೆ ಆಗ್ತದೆ, ಈ ರೀತಿ ತಂದ್ರೆ ಫೆಡರಲ್ ಸ್ಟ್ರಕ್ಚರ್ಗೆನೆ ತೊಂದರೆ ಆಗ್ತದೆ ಅಂತಕ್ಕಂಥ ವಿಚಾರಗಳು. ಅದೇ ರೀತಿ ಇವರು ಒಂದು ಅಕೌಂಟಬಿಲಿಟಿ ಅಂತಕ್ಕಂಥದ್ದನ್ನ ಒಂದು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ಗೆ ಅಲ್ಲ, ಡಾಕ್ಟರ್ಸ್ಗೂ ಇರಬೇಕು, ಲಾಯರ್ಸ್ಗೂ ಇರಬೇಕು, ಜಡ್ಜಸ್ಗೂ ಇರಬೇಕು, ಪಾಲಿಟಿಷಿಯನ್ಸ್ಗೂ ಅಕೌಂಟಬಿಲಿಟಿ ಇರಲೇಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ ಈ ರೆಗ್ಯುಲೇಟರಿ ಮೆಕಾನಿಸಮ್ ಇಲ್ಲ ಅಂದ್ರೆ ಬಹಳ ತೊಂದರೆ ಆಗ್ತದೆ.
ಅಂದ್ರೆ ಎಲ್ಲಾ ಪ್ರೊಫೆಷನ್ಸ್ಗೂ ಒಂದೇ ತರ ರೂಲ್ಸ್ ಇರಬೇಕು, ಇಲ್ಲ
ಅದೇ ಇರಬೇಕು, ಇಲ್ಲ ಅದೇ ಇರಬೇಕು ಅಂತ ಅಭಿಪ್ರಾಯ. ಕರೆಕ್ಟ್
ಸರ್. ಈಗ IPC ಮತ್ತು ಈಗ ರೀಸೆಂಟ್ ಆಗಿ ಬರಂತ BNS IPC 304 ದಲ್ಲಿ ಏನೋ ಡಾಕ್ಟರ್ಸ್ ಏನಂತ ಓನ್ಲಿ ಪೆನಾಲ್ಟಿ ಆರ್ ಪನಿಷ್ಮೆಂಟ್ ಅಂತ ಇತ್ತು ಮೊದಲು.
ಅದಿಲ್ಲ ಇವಾಗ ಇಂಡಿಯನ್ ಪೆನಲ್ ಕೋಡ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಪೀಲ್ಡ್.
BNS ನಲ್ಲಿ ಪನಿಷ್ಮೆಂಟ್ ಆಸ್ ವೆಲ್ ಆಸ್ ಇದು ಏನಂತಾರೆ ಪೆನಾಲ್ಟಿ ಅಂತ ನೋಡಿದಾವ ಅಂತ ಹೇಳಿ
ಸೆಂಟೆನ್ಸ್ ಇದೆ, ಸೆಂಟೆನ್ಸ್ ಇದೆ, ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಇದೆ.
So
good evening, good evening, Lordship. Good evening.
Good evening, Kanitkar. How are you?
Fine. I'm fine.
You are in Shumaga. I'm coming to Shumaga. Day after tomorrow, I'm coming to Shumaga.
Yes, sir. Yes.
ತೀರ್ಥಹಳ್ಳಿಗೆ ಬರ್ತೀನಿ. ಅದೇ ನಮ್ಮ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಮಗಳದು ಎಂತದ ಮಂತ್ರ ಮಾಂಗಲ್ಯದು. ಐ ಆಮ್ ದಿ ಚೀಫ್ ಗೆಸ್ಟ್.
ಅದೇ. Lordship, whether you think accountability of the government doctors also necessary?
Because ಅದೇನು ಇದೆಯಲ್ಲ, they are also necessary.
Rampant negligence in the government hospitals.
ಎಲ್ಲರೂ wholesale.
More death, recent Ballari deaths.
ಹೌದು,
ರೆಫರ್
ಮಾಡಿದೆ. ಬಟ್ ಅದು ನೆಗ್ಲಿಜೆನ್ಸ್ ಅಲ್ಲಿ ಡ್ರಗ್ ಸಪ್ಲೈ ಮಾಡೋದ್ರಿಂದ ನೆಗ್ಲಿಜೆನ್ಸ್ ನೋಡ್ಲೇ ಇಲ್ಲ. ಅದೇನೋ ಸೊಲ್ಯೂಷನ್ ಇದೆಯಲ್ಲ, ಆ ಸೊಲ್ಯೂಷನ್ ಸರಿಯಾಗಿ ಡ್ರಗ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ರಾಂಗ್. ಅದು
the same should be brought under consumer protection also, what I feel.
ನಾವು ಇದೆ ಪ್ರತಿಯೊಬ್ಬರು they will come under the protection act, consumer protection act ಬರ್ತಾರೆ ಅವರು.
Because they take the defense, we are doing free service.
No,
exemption. VP Shantadag ಹೇಳಿದಾರ,
ಹೇಳಿದ್ದಾರೆ,
exempted from the.
That cannot be a defense at all. Such a defense is not permissible, according to me.
Now I invite Dr. Suriraj to ask his question.
ಅಲ್ಲ, ಅದೇನೆ ಅವ್ರು ಹೇಳ್ತಿದ್ದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಫ್ ಸರ್ವಿಸ್, ಫ್ರೀ ಸರ್ವಿಸ್ ಅಂತ. ಅದನ್ನ ಸ್ವಲ್ಪ ಅಮೆಂಡ್ ಮಾಡ್ತಾರೆ, ಆಯ್ತು ಅಷ್ಟೇ.
ಇಲ್ಲ,
ಸರ್ವಿಸ್
ಈವನ್ ಅವರು ರಿಜಿಸ್ಟ್ರೇಷನ್ ಕೊಡುವಂತ ₹5 ಆಗ್ಲಿ, ಎಕ್ಸ್ರೇ ಕೊಡುವ ₹10 ಆಗ್ಲಿ, ದಟ್ಸ್ ಆಲ್ಸೋ ಅಂಡರ್ CP.
Not only that, it is the statute, constitutional obligation on the part of the state to provide health. Their money is being appropriated in the budget allocation. Salaries are being paid out of the income tax consolidated fund. ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಅದು ಅದನ್ನ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಗಿ ಮಾಡ್ಬೇಕು. ಆಗ ಮಾಡಿದಾಗ್ಲೇನೆ ಅವನ್ನ ಅಲ್ಲಿ ತರಕ್ಕಾಗುತ್ತೆ.
Dr. Suriraj.
Good evening, sir. Justice, sir. I have one doubt. I'm a surgeon. There is always a fear about taking risks, sir, in the hospitals these days. Fear about the litigations, risks. See, when we operate on the patient, there is certain risk will be there, irrespective of the best surgical skills. Outcome is dependent upon many factors like age. Sometimes, unexpected complications may arise and outcome will be bad. It depends on many factors. During that situation, suddenly patient attenders going to the police station and taking an order, they killed my relative, and we get an arrest warrant, something like that. Is there any immunity to the doctors to protect themselves? Because doctors consider these kind of arrests worse than a suicide or deaths. So, what is your opinion, sir?
ಇಮ್ಯುನಿಟಿ ಇಲ್ಲ. ಇಮ್ಯುನಿಟಿ ಇವಾಗ ಜಡ್ಜಸ್ಗೆ ಇಮ್ಯುನಿಟಿ ಇದೆ, ನಿಮಗೆ ಇಮ್ಯುನಿಟಿ ಇಲ್ಲ. ಅದು ಡಿಪೆಂಡ್ಸ್ ಅಪಾನ್ ಅನ್ನೆಸರಿಲಿ ನಿಮ್ಮನ್ನ ಇಂಪ್ಲಿಕೇಟ್ ಮಾಡ್ತಾರೆ, ನೀವು ಫೇಸ್ ಟ್ರಯಲ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಅನ್ನೋದು ಕರೆಕ್ಟ್ ಇದೆ. ಅದನ್ನ ಕೇಸ್ ಟ್ರಯಲ್ ಇಲ್ದೇನೆ ನೀವು ರೆಕಾರ್ಡು ಅದನ್ನೆಲ್ಲ ಮಾಡಿ ಆ ಫ್ಯಾಕ್ಟ್ ತೋರಿಸಿ ನಿಮ್ಮನ್ನೆಲ್ಲ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೋದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ನಲ್ಲಿ. ಅದು ಒಳ್ಳೆ ಲಾಯರು. ನಿಮ್ಮ ಮೆಟೀರಿಯಲ್, ಆ ಡಾಕ್ಯುಮೆಂಟ್ರಿ ಮೆಟೀರಿಯಲ್ ಇರ್ಬೋದು. ಆ ರೀಸನ್ ಅದಕ್ಕೋಸ್ಕರ ನಿಮ್ಮ ಕೇಸ್ ಶೀಟ್ ನಲ್ಲಿ ಬರೆಯೋದು, ಪ್ರತಿಯೊಂದು ಡಾಕ್ಟರ್ ಬಂದಾಗ PP ಎಷ್ಟಿದೆ, ಇದು ಬ್ಲಡ್ ಶುಗರ್ ಎಷ್ಟಿದೆ, ಆಮೇಲೆ ಕಾಂಪ್ಲಿಕೇಶನ್ ಏನು ಆಗ್ತಾ ಇದೆ, ಇವಾಗ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡ್ತಿರೋದು ರೆಸ್ಪಾಂಡ್ ಆಗ್ತಾ ಇದ್ದಾರಾ ಇಲ್ವಾ, ಈಗೆಲ್ಲ ಬರಿತೀರಲ್ಲ, ಆ ಬರೆಯುವಾಗ ಕರೆಕ್ಟಾಗಿ ಬರಿಬೇಕು. ಅದರಲ್ಲಿ ಅಲ್ಲಿ ಬಂದು ತೋರಿಸ್ಬೇಕು ಜಡ್ಜ್ಗೆ, ವಿ ಆರ್ ನಥಿಂಗ್, these are the subsequent complication developed within the body that did not react properly. They did not withstand the surgical treatment ಅಂತ ಬರೀಬೇಕು ಅಲ್ಲಿ ಆ ಕೇಸ್ ಶೀಟ್ನಲ್ಲಿ ಬರೀತಕ್ಕಂಥದ್ದು ಬಹಳ ಇಂಪಾರ್ಟೆಂಟು. ನಿಮ್ಮ ಡಾಕ್ಟರ್ಸು ನೀವು ಸರ್ಜರಿ ಮಾಡ್ಬಿಟ್ಟು ಆದ್ಮೇಲೆ ಎವ್ರಿ ಡೇ ಹೋಗಿ ಮಾಡ್ತಾರಲ್ಲ ಪೋಸ್ಟ್ ಕೇರ್ ಟ್ರೀಟ್ಮೆಂಟು, ಅದನ್ನ ಪ್ರತಿಯೊಂದು ಆಸ್ಪೆಕ್ಟ್ ಆ ಕೇಸ್ ಶೀಟ್ ನಲ್ಲಿ ಬರೀಬೇಕು.
I understand, sir. This before trial it happens. Suppose
ಹೌದು,
before trial, if you get an arrest.
ನಿಮ್ಮಿಂದ ಆಗಿಲ್ಲ ಅದು ನೆಗ್ಲಿಜೆನ್ಸ್ ಅಂತಕ್ಕಂಥದ್ದನ್ನ ಎಲಿಮೆಂಟ್ ಅನ್ನ ಆ ಕೇಸ್ ಶೀಟ್ ಇಂದ ತೋರಿಸಬಹುದು ನೀವು, ನಾನು ಹೇಳೋದು.
Okay.
ಅದಕ್ಕೆ ನೀವು ನಿಮ್ಮ ಅಸಿಸ್ಟೆಂಟ್ಸ್ಗೆಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಡಬೇಕು. ಇವಾಗ ಏನೇನಾಗ್ತಾ ಇದೆ, ಏನು ಪ್ರೋಟೋಕಾಲು ಅದೆಲ್ಲ ಸರಿ ಮೇಂಟೈನ್ ಮಾಡಿದಾರಾ ಇಲ್ವಾ, ಅದು ಏನ್ ಡೆವಲಪ್ ಆಗ್ತಾ ಇದೆ, ಇವೆಲ್ಲ ಯಾಕೆ ಆಗಿದೆ, ಅದನ್ನೊಂದು ಬರೆದು ಬಿಡ್ಬೇಕಲ್ಲಿ. ಬರೆದು ಬಿಟ್ರೆ ನಿಮಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಸಿಗ್ತದೆ ಅವಾಗ.
ಸರ್, ಅದು ಅಂತ ಸಿಚುವೇಶನ್ ಆದಾಗ, ಒಂದು ಕೇಸ್ ಆದಾಗ ನಮ್ಮ ಹಾಸ್ಪಿಟಲ್ ಮೇಲೆ ಅಥವಾ ನಮ್ಮ ಮೇಲೆ, ಡಾಕ್ಟರ್ಸ್ ತುಂಬಾ ಇಂಥ ಒಂದು ಕ್ಲೋಸ್ ಎನ್ವೈರನ್ಮೆಂಟ್ ಅಲ್ಲಿ, ಒಂದು ಸಾಫ್ಟ್ ಎನ್ವೈರನ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯೂಶಲಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ಇಂಥದ್ದೊಂದು ಪಬ್ಲಿಕ್ ರ್ಯಾಶ್ ಬಂದಾಗ, ಪೊಲೀಸ್ ಹಾಸ್ಪಿಟಲ್ ಬಂದಾಗ ವಿ ಗೆಟ್ ವೆರಿ ಸ್ಕೇರ್ಡ್. ತುಂಬಾ ಡಾಕ್ಟರ್ಸ್ ಸೂಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಇದೆ, ನಂದು ರೆಪ್ಯುಟೇಷನ್ ಹಾಳಾಯ್ತು ಹಂಗೆಲ್ಲ ಅನ್ಕೊಂಡು. ಅಂತ ಡಾಕ್ಟರ್ಗೆ ಅಥವಾ ಡಾಕ್ಟರ್ ಕಮ್ಯುನಿಟಿಗೆ ನಿಮ್ದು ಏನ್ ಮೆಸೇಜ್ ಈ ರೀತಿ ಬಂದಾಗ?
ಧೈರ್ಯವಾಗಿರ್ಬೇಕು, ಧೈರ್ಯವಾಗಿ ಫೇಸ್ ಮಾಡ್ಬೇಕು. ಅದಕ್ಕೆ ಅವೇರ್ನೆಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು, ಸೂಸೈಡಲ್ ಟೆಂಡೆನ್ಸಿ ಇರಬಾರ್ದು, ಸ್ಟ್ರಾಂಗ್ ವಿಲ್ ಪವರ್ ಇರಬೇಕು ಅಂತಕ್ಕಂಥದ್ದು, ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಅವಶ್ಯಕತೆ ಇದೆ.
Recently, 1 year back or 2 years back in Rajasthan, what happened, sir? Due to maternal death, a doctor was arrested. Means she got an arrest warrant. Fearing about the arrest, doctor committed suicide.
ಅರೆಸ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ರೆಪ್ಯುಟೇಷನ್ ಹೋಗುತ್ತೆ, ಪಬ್ಲಿಕ್ ಎಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ ಅಂತ ಪಾಪ ಅದೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಬರ್ತದೆ.
So that is why, sir, these days doctors also having that fear to take the risks. In emergency wards, many of the second tier and third tier cities, they are not taking many emergency cases, sir. Because
there is also cause.
Yes, sir.
ಇವಾಗ ನಾವ್ಯಾಕಪ್ಪ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು ತಗೊಳ್ತಾ ಇಲ್ಲ ಬಹಳ ಜನರು.
In the patients ಕೂಡ ಅಷ್ಟೇ ಲಾಸಸ್, ಸರ್. ಡಾಕ್ಟರ್ಸ್ ಫಿಯರ್ ಮತ್ತೆ ಪೇಷಂಟ್ಸ್
ಅದು ಟ್ರೀಟ್ಮೆಂಟ್ ಸರಿಯಾದವ್ರು ಸಿಕ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಸತ್ತೋಗ್ಬಿಡ್ತಾರೆ.
ಈ ತರ ಆಗ್ತಾ ಇದೆ.
ಹೌದೌದು. ಇಟ್ ವಿಲ್ ರಿಸಲ್ಟ್ ಈಸ್ ದ್ಯಾಟ್. ಅದಕ್ಕೋಸ್ಕರ ಇದನ್ನೆಲ್ಲ ಪ್ರೊಟೆಕ್ಷನ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಅವಶ್ಯಕತೆ ಇದೆ. ಬಟ್ ತೀರಾ ನೆಗ್ಲಿಜೆನ್ಸ್ ಇರ್ತಕ್ಕಂಥವ್ರಿಗೆ ಇದು ಮಾಡ್ತಕ್ಕಂಥದ್ದು ಅವಶ್ಯಕತೆ ಇದೆ.
The Jacob Matthews case, Jacob Matthews has given some relief to the doctors, Lordship. No police officer shall arrest immediately unless
you are satisfied.
See it should be sent to the board initially, and
then afterwards, after their opinion, you must.
Then only, because that will save the doctors, I think.
I think we should advise all the doctors to keep one copy.
Copy of Jacob Matthews.
Adan kalsi avarge.
Kalstin. Soft copy I will send.
Thank you, sir.
ರಾಮಚಂದ್ರ ಅವರೇ, ನಾನು ಕೊಡ್ತೀನಿ. ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ನನ್ನ ಹತ್ರ ಇಲ್ಲ. ಅದನ್ನು ಬೇಕು ಅಂದ್ರೆ ನಾನು ಸಪ್ಲೈ ಮಾಡ್ತೇನೆ. ನಮ್ಮ ಇವ್ರು ಕೊಡ್ತಾರೆ, ಕನೆಕ್ಟರ್ ಕೊಡ್ತಾರೆ ನಿಮಗೆ. ಇದನ್ನ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿ ನಾನು ಇದನ್ನ ನಿಮ್ಗೆ ಕೊಡ್ತೀನಿ.
Dr. Dhiren Mehta, if you want to ask your question. If he's not there, his question is, sir, right to live and die with dignity. There is a right to live also, right to die also with dignity. How can we balance the terminally ill patient where there is a conflict between the relatives and patient is not able to take the...
ಅಲ್ಲ, ಅದು ಯುಥನಾಸಿಯಾ ಇದೆಯಲ್ಲ, ಅದನ್ನ ಮಾಡ್ಬೋದು ಅಂತ ವಿತಿನ್ ದಿ ಗೈಡ್ ಲೈನ್ಸ್ ನಲ್ಲಿ ನೀವು ಅದನ್ನ ಮಾಡ್ಬೋದು ಅಂತ ಇದೆ.
ಪೇಷಂಟ್ ಅನ್ಕಾನ್ಶಿಯಸ್ ಇರ್ತಾರೆ, ಅಮೌಂಟ್ ದ ರಿಲೇಟಿವ್ಸ್ ದೇರ್ ಇಸ್ ಎ
ರಿಲೇಟಿವ್ಸ್ ಹಸ್ಬೆಂಡ್ ವೈಫ್ ಸಣ್ಣ ಒಂದು ಜವಾಬ್ದಾರಿ ತಗೋಬೇಕು ಅಷ್ಟೇ. ಅದು ಬರೀಬೇಕು. ಅನ್ಕಾನ್ಶಿಯಸ್ ಇದ್ದಾರೆ, ಮತ್ತೆ ಇಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಅವನು ಅಭಿಪ್ರಾಯ ತಗೊಳಕ್ ಆಗಲ್ಲ, ಅವ್ರ ರಿಲೇಟಿವ್ ಅಭಿಪ್ರಾಯ ವೈಫ್ದು ಅಥವಾ ಸನ್ದು ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಅನ್ನೆಸರಿ ಸಫರಿಂಗ್ ಗಿಂತಲೂ ಕೂಡ ಇವರು ಈ ರೀತಿ ವಿತ್ ಡಿಗ್ನಿಟಿ ಯುಥನಾಸಿಯಾ ಈಸ್ ಪರ್ಮಿಸಿಬಲ್, ಅದಕ್ಕೆ ನೀವು ಆ ರೀತಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ಬೇಕು ಅವರು.
ಅಂದ್ರೆ ಡಿಸಿಷನ್ ವಿ ಶುಡ್ ಗೋ ಫಾರ್ ದಿ ಇಮಿಡಿಯೇಟ್ ಗಾರ್ಡಿಯನ್.
ಹೌದು, ಇಮಿಡಿಯೇಟ್ ಗಾರ್ಡಿಯನ್ ಹೂ ಇಸ್ ಯಾರಂದ್ರೆ ಅವ್ರು ಕೊಡಕ್ಕಾಗಲ್ಲ.
Dr. Ravi Prakash?
Yeah, good evening, sir. I'm Dr. Ravi Prakash, a psychiatrist basically. I have a little different kind of a question, sir. So, in general, about fundamental rights, lot of arguments are going on. But there is something called as fundamental duties also, enshrined in Part 4A of the Indian Constitution. And when the health has been already included under Article 21, there have been several committees as well as judgments who have made this clear that the fundamental duties should also be enforced. Now, when we imply the fundamental duties to the medical health profession, it is basically about developing scientific temper and the provision of having a scientific responsibility towards the patient. So, in that, if the patient does not follow something what doctor is saying, and subsequently it takes a turn where the patient faces the consequence, or if the patient is not following the instructions of the doctor, which happens very commonly, especially in my profession as a psychiatrist. So,
Definitely.
shouldn't there be any kind of enforceability of fundamental duties
Yeah,
here?
definitely. The fundamental duties, they must, they rightly you have pointed out, if they don't follow the procedure of treatment, then you are ceased to be not responsible. The patient
So
and
that is,
patients.
yes, that I am understanding, sir. But
Hmm.
should it be legally enforceable at some level at least so that they also
Definitely.
understand?
Why not? They have not followed the course of treatment, therefore you are not responsible. They are responsible. It is their duty. This is not one side. The post care, and you tell that these are the medicines you have to take. Whether they're taken or not is the question of fact. That has to be elicited. That should be reflected.
So my next question is that if suppose something like this happens where because the patient has not followed the instruction of the doctor
Hmm.
and police anyhow comes to suppose he does not come to arrest you just for the purpose of investigation. Okay, do we have the right to like produce
Yes, definitely you
uh,
can tell the investigation officer, I am not accountable, I am not answerable, I am not responsible for post care. He has not taken care of it because of his fault. He has developed complications, and the resultant is the death. I am not responsible. You can tell investigation officer, you must to show these are prescription, whether they are taken or not. Please investigate them. They must tell that. They have to. They must also answerable to the IO. Proper investigation must be made by the IO.
okay, so this was one of my questions, sir. Thank you. I've just done my LLB, sir, so I'm also
Oh,
kind of
that's why you are speaking fundamental duty.
thank
The
Dr.
observation
Rohan?
is that many doctors are taking up the law. They try to understand law. They want to go for postgraduate diploma courses in law, and that is one good move. Good.
Yes, good move. Definitely, you must conduct workshops. You must get educated, create awareness with the medical jurisprudence, legal jurisprudence.
The main problem, the doctors are they're worried about going to court, facing judiciary and police department. If they are very sure about, then definitely all these problems will come down. There is
Yes, definitely. No, they must be in a position to tackle the IO, tackle these people, everything. Then they will also be very careful.
So, Dr. Rohan, you're there. You want to ask a question? Okay. If any other
10:30, Doctor Sir, it is 10:30. It's time to wind up.
Yeah, please, sir. With this, I conclude the session, sir, with your permission.
Somebody asked me about the trade license. Trade license is something related to the administration, whether we should have trade license and all that. Justice sir, do you have any answer for this? Trade license for doctors to start a clinic or to start the nursing homes or any.
ಅವೆಲ್ಲ ಬೇಕಲ್ಲ. ಲೋಕಲ್ ಸೆಲ್ಫ್ ಗವರ್ಮೆಂಟ್ ನಲ್ಲಿ ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ ಅಂತ ರಿಜಿಸ್ಟರ್ ಮಾಡಲೇಬೇಕು ನೀವು. ಅವೆಲ್ಲ ಬೇಕು. ಟ್ರೇಡ್ ಅಂತಲ್ಲ, ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ ಅದಕ್ಕೆ ಮುನ್ಸಿಪಲ್ ಕಾರ್ಪೊರೇಷನ್ ಆಕ್ಟ್ ನಲ್ಲಿ, ಮುನ್ಸಿಪಾಲಿಟಿಯಲ್ಲಿ, ಆಮೇಲೆ ನಿಮ್ದು IMA ಮೆಡಿಕಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಇದೆಲ್ಲ ಬೇಕಾಗುತ್ತೆ.
ಸರ್, ಇತ್ತೀಚೆಗೆ ನಮಗೆ ಫೈರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸ್ವಲ್ಪ ಇಶ್ಯೂಸ್ ಬರ್ತಿದೆ ಸರ್, ನಿಮ್ಮ ಗಮನಕ್ಕೆ ಇರ್ಲಿ. ನಾವು ಇನ್ಫಾರ್ಮೇಶನ್ ತಗೊಳ್ಳಿಕ್ಕೂ ಬೇಕಾದ್ರೂ ವಿ ಹ್ಯಾವ್ ಟು ಪೇ ಅರೌಂಡ್ 1 lakh and get the information. All that things are happening in fire department.
ಏನಕ್ಕೆ ಬೈ?
ಅದು ಈಗ ಫೈರ್ ಲೈಸೆನ್ಸ್ ಮ್ಯಾಂಡೇಟರಿ ಮಾಡಿದ್ದಾರೆ. ಐ ಥಿಂಕ್
ನರ್ಸಿಂಗ್ ಹೋಮ್ಸ್ಗೆ,
ನರ್ಸಿಂಗ್ ಹೋಮ್ಸ್ ಮತ್ತೆ ಎಲ್ಲ, ಇವನ್ ಫಾರ್ ಕ್ಲಿನಿಕ್ಸ್.
ಕ್ಲಿನಿಕ್ಸ್ ಏನಕ್ಕೆ ಬೇಕು?
I think President will narrate this Do we have present here? Okay.
No, no.
ಇತ್ತೀಚೆಗೆ ಏನಾಯ್ತು ಅಂದ್ರೆ
ಅಲ್ಲಿ ಕ್ಲಿನಿಕ್ಸ್ ಯಾಕೆ ಫೈರ್ ಸರ್ವಿಸ್ ಬೇಕಂತೆ?
ಅದು ನಾವು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ ತಗೋಬೇಕು.
ಎಲ್ಲಿ, ಯಾರಿಂದ?
ಫ್ರಮ್ ದ ಫೈರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ಏನಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ನೀವು? ಓನ್ಲಿ ನರ್ಸಿಂಗ್ ಹೋಮ್ ಬೇಕು ಅಷ್ಟೇ, ನೀವು ಕ್ಲಿನಿಕ್ ಯಾಕೆ ಬೇಕು?
ಒನ್ ಫಾರ್ ಸ್ಮಾಲ್ ಕ್ಲಿನಿಕ್ಸ್ ಸತಿಗೆ ಅಲ್ಲಿಂದ 21 ಮೀಟರ್ಗಿಂತ ಕೆಳಗಿರೋರಿಗೆ NOC ಅಂತಂತೇಳಿ ಅಂತೆಲ್ಲ, ಅಂದ್ರೆ ವಿ ಹ್ಯಾವ್ ಟು ಪ್ರೊವೈಡ್ ಆಲ್ ದಿ ಫೆಸಿಲಿಟೀಸ್ ಆಫ್ ಎಕ್ಸ್ಟಿಂಗ್ವಿಷರ್ಸ್ ಅವೆಲ್ಲ ಇಡಬೇಕು.
ಸರಿ, ಅದೆಲ್ಲ ಬೇಕು.
ಅದನ್ನು ಮತ್ತೆ ಏನಂತಲ್ಲ 21 ಮೀಟರ್ ಒಳಗಿರೋರಿಗೆ, ಆಮೇಲೆ 21 ಮೀಟರ್ ಮೇಲೆ ಇರುವಂತಹ ನರ್ಸಿಂಗ್ ಹೋಮ್ಗಳಿಗೆ
ನರ್ಸಿಂಗ್ ಹೋಮ್ ಇಸ್ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ಕ್ಲಿನಿಕ್.
ಕ್ಲಿನಿಕ್ ಕೂಡ ಸರ್, ಅದಕ್ಕೆ ಅದು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲ, ಅಡ್ವೈಸರಿ ಅಂತ. ಅದಕ್ಕೆ ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬೇಕು. ಅಪ್ಲಿಕೇಶನ್ ಸುಮಾರು 1 ಲಕ್ಷ ರೂಪಾಯಿ ಪೇ ಮಾಡಬೇಕು ವರ್ಷಕ್ಕೆ.
ಅದೆಲ್ಲ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಐ ಡೋಂಟ್ ಥಿಂಕ್ ದ ಕ್ಲಿನಿಕ್ಸ್ಗೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಅಪ್ಲಿಕಬಲ್.
ಎಸ್ ಸರ್, ಅದು ಅದಕ್ಕೆ
somebody must challenge it. Somebody must challenge it. You must get a decision from the High Court.
We are in the process, sir. We are in the process of meeting.
They are not supposed to insist upon the doctors who are running clinics. No.
ಕ್ಲಿನಿಕ್ಸ್ಗೆ 50,000 ರೂಪಾಯಿ, ಆಮೇಲೆ ನರ್ಸಿಂಗ್ ಹೋಮ್ಸ್ಗೆ 1 ಲಕ್ಷ ರೂಪಾಯಿ.
ಫೈರ್ ಸರ್ವಿಸಸ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಬೇಕಾಗಿರೋದು ಇಫ್ ಯು ಆರ್ ರನ್ನಿಂಗ್ ಎಮರ್ಜೆನ್ಸಿ ಆದ್ರೆ ಅಲ್ಲಿ ಫೈರ್ ಇಂಜಿನ್ ಬರಬೇಕು ಅದಲ್ಲ ಅಂತ. ಏನ್ ಎಮರ್ಜೆನ್ಸಿ ನಿಮ್ದು? ಒಳ್ಳೆ ಕಥೆ ಆಯ್ತಲ್ಲ. ಇವಾಗ ಆ ಪ್ರಿನ್ಸಿಪಲ್ ಆಗಿ ಅಪ್ಲೈ ಆದ್ರೆ ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ ಬೇರೆಯವ್ನು ಯಾವನೋ ಒಂದು ಅಂಗಡಿ ಇಟ್ಟಿರ್ತಾನೆ, ಟ್ರೇಡ್ ಮಾಡೋನ್ಗೆ ಅವ್ನಿಗೆ ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ತಾನ?
ಅದೇ ಸರ್, ಇವನ್ ಸ್ಕೂಲ್
ರಿಟ್ ಹಾಕಿ ಯಾವ್ದನ್ನ ಅವನ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ತಗೊಂಡು ರಿಟ್ ಒಂದು ಹಾಕಿದ್ರೆ ಹೋಗುತ್ತೆ.
ಆಕ್ಚುಲಿ ಸ್ಕೂಲ್ಗಳಿಗೆಲ್ಲ ಕನ್ಸೆಷನ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಸರ್.
ಅಲ್ಲಲ್ಲ, ಸ್ಕೂಲ್ಗೆ ಕನ್ಸೆಷನ್ ಕೊಡುವ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಅಲ್ಲಿ 1,000 ಜನ ಇರ್ತಾರೆ. ನಿಮ್ಮಲ್ಲಿ ಏನು ಒಂದು ಬರುವನು ಹೋಗೋನು ಮ್ಯಾಕ್ಸಿಮಮ್ 10 ಜನ ಇರ್ತಾರೆ ಕಾಯ್ಕೊಂಡು. ನಿಮಗೆ ಯಾಕೆ ಫೈರ್ ಸರ್ವಿಸ್? ಸ್ಕೂಲ್ ಸ್ಟ್ರಿಕ್ಟ್ನೆಸ್ ನಲ್ಲಿ ಫೈರ್ ಸರ್ವಿಸ್ ಬೇಕು.
Can I have word? Yes. ಇವರು ಫೈರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಏನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂತಂದ್ರೆ, ಇಟ್ಸ್ ದಿ ಒನ್ಸ್ ಇನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಏನೋ ಒಂದು ಆರ್ಡರ್ ಬಂತು. ಆಕ್ಚುಲಿ 2 ಕಡೆ ಫೈರ್ ಎಲ್ಲ ಆದಾಗ they said the fire extinguishers should be there and it should be
fire extinguishers irudu
get the NOC from this one anta bantu. But the government, state governments, they took it in a different way, and the administrators, they made it mandatory for the clinics also, from clinics to the nursing homes.
Ado is it by way of a circular? Is it by way of a government order? Please let me know, then I will tell you.
Okay.
Please give me, make it available, then I will give my opinion.
Yes, I will do that.
Yeah. Kindly wind up the.
Yeah. With your permission, sir, thank you very much for spending your precious time and you are sharing your vast experience and advices regarding the topic and other queries also of our attendees. Thank you once again, sir, Justice V. Gopal Gowda, sir. And I also thank our President, sir, Secretary, sir, and our Medical Legal Subcommittee Chairman, Dr. Harish, also for giving this opportunity to conduct this webinar. And I thank all the attendees who patiently heard the session, which was so interesting for 1.5 hours. And asked the questions. I'm sure that most of you got enlightened and got your answers for your queries. Thank you once again. Thank you.
Special thanks to Dr. Kantikar sir also. We appreciate it.
Yes.
Thank you.
No, Kantikar must give the judgment.
Yes, I will send the IMA. Jacob Matthews.
Soft copy, give it to them.
Jacob Matthews and Lordship, your judgment, 2014. 100
No, that 100. They know it. My judgment, they know it.
Yes.
It is in the Supreme Court cases.
Yes.
Dr. Kantikar has also given one wonderful judgment regarding informed consent.
2004 volume 1 is Balram case. 2004 1 SEC, page 384.
2014 4, sir.
2014 1 SEC.
One SSC 100.
384.
Yes.
Balram Prasad versus Kunal Shah and others.
Kunal Shah, yes.
2867 of 2000.
Thank you.
Thank
I will give Ramchandra. I will give this to you tomorrow.
Yes, sir. Sure, sir.
You will get this the presentation with reference to the judgments.
Sure, sir. I will later. I will circulate among our.
Circulate among
Sure,
us.
sure, sir.
And that soft copy.
Yes.
Thank you, sir.
Thank you, sir.
Good night.
Thank you
Thank
for all
you.
the IMA KSB members as well office bearers for joining. Very kind of you. Good night.
Thank you.
Thank you. Good night.